Honorable members, the Oilfields Regulation and Development Amendment Bill 2024. Honorable Sri Hardeep Singh Puri ji to move a motion for consideration of the Oilfields Regulation and Development Amendment Bill 2024. Mani Puri ji.
Mr. Chairman, sir, with your permission, I rise to move that the Oilfields Regulation and Development Amendment Bill 2024, further to amend the Oilfields Regulation and Development Act 1948, be taken into consideration. Sir, I would like to do some context setting for the proposed amendment bill, which is being placed for consideration before this August House today. Sir, as the world's fastest growing large economy, India is on its journey from a current GDP of $4 trillion, hopefully in the foreseeable future to become a $7, $8, $10 trillion GDP on to Viksit Bharat by 2047. So this is a sankalp, a resolve espoused by the Honorable Prime Minister. The entire nation, our people and the government are steadfastly committed to ensuring the successful fulfillment of this resolve. Sir, for the growth of any economy, it becomes clear that energy is not only a vital component, but is actually the lifeline of the economy. Invariably, when energy consumption levels are seen to be rising, it is a sure sign, sir, of growing economic activity and GDP growth. In fact, if you look around the world today and you see some of the large economies, one particular one which has a $20 trillion economy, and you look at what's happening inside there, you can get a reasonably good idea by looking at the levels of energy consumption. So, for any democratically elected government, it becomes essential to ensure, and especially ones which have a large population like ours, to ensure that the three challenges of availability, affordability, and sustainability, these challenges are met. And I can say before this House, sir, with a reasonable degree of satisfaction, that in the last 10 years, and even earlier, but certainly in the last 10 years, all three have been ensured, more so with greater degree of success. And in the midst of global uncertainty and volatility, when there was an economic lockdown, sir, in the world, the price of a barrel of crude had come down to something like $19.56. And yet, when economic activity resumed, that $19 shot up to over $128. And yet, sir, in India, for the last 3 years, if we use that as a reference period, I can say with confidence we are perhaps the only country in the world where prices of energy, and I talk about at the retail point, petrol and diesel, have actually come down. In an area where, in the neighborhood, they have not only shot up, but there are very serious issues of non-availability. So we currently produce about 30 million metric tons of crude oil and 36.5 billion cubic meters of natural gas annually. As against this production, sir, we consume 235 million metric tons of petroleum products and 68 billion cubic meters of natural gas. There is clearly a very large gap between what we produce and what we consume. And on this, we could have an entire day's discussion. But I will stick to some of the more evident features. Sir, when I had the privilege of joining this ministry 3 years ago, our daily consumption of crude in terms of millions of barrels was 5 million barrels a day. In the 3 years, sir, this has gone up to 5.4 million barrels a day. And I can say with a reasonable degree of confidence that in another year or so, this 5.4 million barrels, if our growth rates remain in the vicinity of 6.5% or so, will go up to 6 million barrels, and so on and so forth. It is vital, therefore, for us to increase exploration and production of oil and gas, both onshore and offshore. And for achieving this, it is necessary for us to address policies and laws which inhibit our efforts. So we have taken a number of steps in this direction. But before I enumerate some of them, I would like to submit to this august House, sir, that exploration and production, by its very definition, requires heavy investment and involves invariably a long gestation period. In other words, if one lets the eye off the ball now, the results will be seen 5-10 years from now. Therefore, in 2016, what will happen is that, no, if I could be a little more explicit, between 2006 and 16, virtually nothing was done on the exploration and production front. Therefore, we had to bear the brunt because the gestation fallout of non-action between 2006 and 14 had to be borne by this government, sir. Why? Because there were some obvious things. There were some projects which were gold-plated. There were some projects where a large number of other things, and then when you audited those projects, people got scared. So invariably, to dig a well offshore requires something in the vicinity of $100 million. And therefore, you have to persevere. Some of the biggest finds in the world in terms of energy have been after big companies. The oil majors have dug 16 wells, had no results, and in the 17th well, suddenly they have. So investment and long gestation periods. So in 2016, in order to avoid the mistakes of the past, I'm not blaming anyone, sir, we went from production sharing regimes to revenue sharing regimes, which are much simpler to implement. If you do a production sharing regime, somebody may turn around and say, well, I didn't spend the $100 which you thought I spent actually $500. So no, let's leave it at that. If you strike oil, let's share the revenue on that. Then, sir, the hydrocarbon exploration and licensing policy, HELP, was introduced by us in 2016, under which 2.5 lakh square kilometers or 144 blocks have been awarded. Of these, 131 blocks, sir, are under active exploration. Cumulatively, these entailed an investment of $3.37 billion US. Then I come, sir, to the open acreage licensing policy from round 1 to 8, where discoveries have been made. Sir, for a long period, our exploration and production efforts were undermined by the fact that out of the total sedimentary basin of 3.5 million square kilometers, there was 1 million square kilometers which was regarded as a no-go area. No-go area means, for some reason or the other, concerns of the Navy, Coast Guard, DRDO, you couldn't explore there. Sir, I'm very happy to inform the House through you, sir, that in the OALP 9th round, that is the open acreage licensing policy in round 9, 38% of the bids that have been received have been in this 1 million square kilometer of no-go area. And, sir, it is my expectation that after this House passes the bill and it is enacted, the OALP round 10, which will be held, which will benefit from the changes that we are seeking to bring through this amendment, sir. Sir, we have also made almost all the geological data available on the National Data Repository, which will start functioning, I'm told, by March, April next year. These measures by the government have borne fruit in increasing focus towards exploration and production and in attracting large-scale investment. Sir, whilst we are making these changes in the oil and gas sector and reforms to make these fit for purpose with the current needs and market conditions, we carried out large-scale stakeholder consultations. By stakeholder consultations, I mean we consulted not only the oil majors in the world, there are only about 5 of them, Exxon, BP, Chevron, Total, ENI, etc., on why they had ceased looking at India as an investment destination. And almost invariably, all of them, including the other stakeholders, told us that our legal framework required not just tweaking, but in some cases, major changes, sir. So we carried out a detailed assessment of the present legal framework, and based on in-house brainstorming and stakeholder discussion, we felt there was a need to align the existing framework with the requirements of the current situation in the world. And for this, I want to point out, sir, the original legislation which we had, which was a comprehensive legislation going back to the year of the Lord 1948. This covered not only petroleum and gas sector, but minings, minerals, metals, the entire range. But I'll come to that in a minute. So the feeling was that we needed to tweak the existing framework with the requirements of contemporary times, including the emergence of new fuels like shale gas, shale oil, coal-based bed methane, natural gas, gas hydrates, the emergence of new technologies like carbon capture, utilization and sequestration, green hydrogen, and new frameworks such as sharing of resources and infrastructure between different operators to improve the viability of oil blocks. And, sir, new concepts like unitization will ensure that even when the natural resources flow between different contiguous blocks, disputes between operators can be resolved amicably. Sir, provisions of the amended Act will ensure that the operators will have a stable tenure in terms of tenure and terms of conditions for the lease. Alternate dispute resolution mechanisms envisaged in the law will ensure that disputes can be resolved in a timely, fair and cost-effective manner. Sir, this bill seeks to eliminate punishments in the form of imprisonment and provide for enhanced penalties to ensure compliance. The bill also seeks to provide for an expeditious mechanism for levy of penalties as well as for handling of appeals arising therefrom. All above provisions that I have mentioned, sir, intend to substantially improve the ease of doing business and make India an attractive destination for enhanced production of oil and gas to monetize our vast reserves. So I had briefly hinted a minute ago that the parent act, the Mines and Minerals Regulation and Development Act, we are seeking to amend through this bill, was enacted as far back as 1948. This was rechristened the Oilfields Regulation and Development Act 1948, when a separate law for the mines and mineral sector was enacted by Parliament in 1957. This 1948 Act continued to carry the weight of the legacy of terminologies used in the mining industry, resulting in difficulties in implementation and delay in carrying on petroleum operations. It was also felt that we needed a more attractive and collaborative approach between the government and the contractors and move away from regulatory control which focused excessively on collecting royalties. So towards this end, we had multiple interactions and sought inputs from different stakeholders operating in the oil and gas sector, both in India and in foreign jurisdictions. We also looked at a few international frameworks in other countries from where we could glean best practices for suitable adoption in this effort to update our legislation and aligning it with our future needs. This amendment bill, therefore, before this August House for consideration, will not only give a fillip for further investments in the oil and gas sector, but also promote ease of doing business, sir. In this effort, we are guided by well-accepted principles and the need for ensuring stability, predictability, and continuity in our policies and laws. Sir, via this amendment bill, we not only intend to do away with the needless mention and regulation of mining activities, which is now dealt with by a separate law, as it already has a sector-specific law, the Mines and Minerals Act of 1957, but also to provide a simple, transparent, and stable regime for petroleum leases and petroleum production activities. We are overhauling the prevalent multiple licenses and lease document paradigm in favor of a single document framework specifying different contours of petroleum mining activities. In order to remove uncertainty, we propose to substitute an acrimonious mode of dispute resolution with a fast and predictable adjudication mechanism and arbitration for leases and authorization granted by the government. Further, sir, to provide a helping hand to small producers, we intend to share infrastructure and other mechanisms providing stability to the ecosystem. Sir, I might add here that our experience has shown that unless there is a drastic simplification in the approach to this resource, and unless we are able to do with multiple crossroads resulting in litigation, into misinterpretation or different kinds of interpretation, the entire sector gets bogged down, as indeed it did for a 10-year period, because of a variety of reasons. As I said, individuals may not be able to blame, but if you have policies which are capable of being, or laws which are capable of being differently interpreted, those who wish to manipulate the system or misuse some of the provisions will happily do so. And therefore, it is intended to provide a clean break from that we are bringing in this amendment and this new bill. We are on course to reduce our committed greenhouse gas emissions and to become net zero by 2070, as the Honourable Prime Minister has resolved. The amendments have also been proposed keeping that commitment in mind. Efforts towards promotion of new and green technologies like green hydrogen, carbon capture and utilization will facilitate the development of comprehensive energy projects, which is the need of the hour. After these amendments to the Oilfields Regulation and Development Act 1948 come into force, we are confident of enhanced participation by oil and gas entities in future bid rounds. And even in anticipation of this legislation, sir, in our outreach to them, we have said, come and join us. If you have the technical competence and expertise, join us in offshore deep sea seismic surveys. You don't need to make a commitment. We will compensate you for your services. And if we strike oil or gas, you will have the right to first refusal. But now we need a legislation which will ensure that what the government has done so far and what we need to do in future to meet the energy requirements of this important sector, which I believe, sir, contributes some 19–20% to government revenues. We are bringing this bill in. With these words, I would conclude and urge honourable members of this august House to support and pass this bill. I thank you, sir.
Thank you.